nor prohibited to it by the states are reserved to the states. So the Constitution has to delegate specifically power to the federal government, and that which is not delegated remains with the states. And that includes the power to prosecute people for committing crimes. Again, this concept goes back to the beginning. Take a look at the Federalist Papers. Federalist number 45, James Madison wrote, "Powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. The state powers reserved to, the powers reserved to the several states extend to all the objects which in the ordinary course of affairs concern the lives, liberties, and properties of the people." This is not a difficult concept. Again, the courts recognize it. In our federal system, the national government possesses limited powers. The states have, and the people retain the remainder. What the court acknowledged in its prior order is called the police power. We have the power to regulate fraud in our elections. Again, they attempted to turn the 10th Amendment on its head, and even if you take a step past that, the Constitution expressly assigns the states the power to regulate elections. We pointed this out in our briefs, but it starts with the Constitution, Article 2, Section 1. It expressly assigns to the states the power to appoint in such manner as the legislature thereof may direct a number of electors. That means that the states determine who their electors are. It's in the Constitution. The Electoral Count Act cannot interfere with that. And again, as the court pointed out, we've made some cites to some of these other cases. In Ray Green, 134 U.S. 377 at 380, an 1890 case. Congress has never undertaken to interfere with the manner of appointing electors or to regulate the conduct of such election or to punish any fraud in voting for electors, but has left these matters to the control of the states. I don't know how much more explicit it can get. The Supreme Court recognized many, many years ago that the state has the power to punish fraud in federal elections. And this issue was kind of taken up again very recently in 2023 by the Supreme Court in Moore v. Harper, 143 Supreme Court 2065. State legislatures must provide a complete code, and this is dealing with the manner of holding elections clause in the part of the Constitution that grants the states the power to conduct federal congressional elections, but it uses the same language as it relates to presidential electors. So the state legislatures have to provide a code for congressional elections that includes regulations relating to notices, registration, supervision of voting, protection of voters, prevention of fraud and corrupt practices, etc. And we would submit to the court that analysis of the word manner as it relates to the congressional elections, the same word is used as it relates to presidential electors, and the same analysis applies. Manner means we have the power to prevent fraud and corrupt practices in our presidential elections. And as the court pointed out, the Supreme Court unanimously held in Chiafalo that Article 2, Section 1 of the Constitution gives the states far-reaching authority over presidential electors absent some other constitutional constraint. And as the court also pointed out, they said that the states have the power to penalize faithless electors. And this is talking about real electors, real actual presidential electors. If there's the power to impose a penalty on the real electors, how does it make any logical sense that the state can't prosecute people who are not electors? I'm going to turn to the safe harbor argument. Defendants contend that if there's pending litigation upon the passing of the safe harbor deadline, then Congress decides who a state's electors are. That's absurd. That flies in the face of Article 2, Section 1. It just doesn't make any sense. Does not authorize, the Electoral Count Act does not authorize multiple slates of electors. It provides a procedure for how to determine which slate is the real slate under state law. And if you look at the Electoral Count Act of 1887, when those disputes arise, Congress has to look at state law and determine was state law followed. But we don't even get there. Because before you get to the issue of multiple slates having been received by the President of the Senate, there's this part of the Electoral Count Act that's being completely ignored. No electoral vote or votes from any state which shall have been regularly given by electors whose appointment has been lawfully certified according to Section 6 of this title, from which but one return has been received, shall be rejected. In 2020, one return was received from the state of Georgia. One return made it to the President of the Senate. And if there's any argument that depends on the fact that more than one return was made, it requires evidence, and there is no evidence in the record at this point. And so let's look at what 3 U.S.C. Section 6 says, and I'm just going to kind of summarize it. It says that the governor ascertains who the electors are after a presidential election, that the governor issues a certificate under the seal of the state, in this case under the seal of the state of Georgia. The governor transmits the certificate of ascertainment to Congress. That is what happened here. The governor issued not one, but 2 certificates of ascertainment that said that these defendants were not the presidential electors for the state of Georgia. And so Congress received one return in 2020 from Georgia. It was certified pursuant to 3 U.S.C. Section 6, and that ends the analysis. All this other stuff about, a dispute, multiple slates, that didn't happen. We don't get there. The defendants were never duly elected and qualified, ever. And that's the real problem. Again, there was one set of votes received by the President of the Senate. There was one set of electors certified by the governor as duly elected and qualified. The Electoral Count Act only contemplates that there could be multiple slates purporting to be legitimate. It does not authorize that. And I think I raised the argument in another brief, but I'll raise it here again. For example, Georgia's criminal code contemplates that people will commit crimes. And it provides instruction on what is to be done when they do commit crimes. Because there's some instruction on what you do when a situation happens, that doesn't mean that the law authorizes it. And again, conclusiveness under the safe harbor provision does not mean that anyone can lawfully purport to be an elector duly elected and qualified by the state of Georgia. Conclusiveness means that if certain requirements are met, it's conclusive that these are the votes. But it doesn't mean that if those requirements aren't met, then they're not the votes, and Congress decides who the real votes are. That's not what the safe harbor provision says. It's just not what it says. Also, contingent electors do not exist under federal law. And this was taken up in the federal court. I referenced it in our brief. I understand that it's persuasive authority here, but there's no reference to contingent electors in any federal law cited by the defendants. The only reference to the idea of something close to a contingent office holder is under OCGA 21-2503. What that statute says is that if an election is contested, then the presumptive winner takes the office on a contingent basis. And then if the election contest is resolved against that person, then the other person comes in and takes the office. It's not clear even that applies to presidential electors in the first place. So this idea of contingent electors, number one, doesn't exist under federal law. Number two, to the extent that it might exist under state law, does not apply here. And also the defendant's safe harbor theory is incongruent with the Constitution. Again, Article 2, Section 1, each state shall appoint in such manner as the legislature thereof may direct a number of electors. This is granting the power to the states to decide who their electors are. And this is fundamental to the way that we elect presidents in this country. The states get to decide who their electors are. They submit a certification, votes of those electors to Congress, and Congress counts them. Under the defendant's theory, their theory is that if an election contest lawsuit is filed in every state at 11:59 p.m. on the day safe harbor passes, Congress gets to choose who every state's electors are. Every state's divested of its constitutional authority to appoint its own electors, and the will of the voters is irrelevant. So if you file a lawsuit under their theory at 11:59 p.m., there's pending litigation, safe harbor evaporates, now Congress gets to decide who wins a presidential election. That makes no sense. Another example, let's say 10,000 election contest lawsuits are filed in Fulton County after an election. Does that mean that the Superior Court bench has to resolve all of those cases prior to safe harbor in order to preserve Georgia's constitutional authority to appoint its electors? It doesn't make sense. It doesn't make sense. I want to touch on Hawaii. We touched briefly on this, and the other side touched briefly on it, but we don't believe that Hawaii is relevant in any way. The facts and circumstances are completely different. Most significantly, in the 1960 Hawaii election, both of the certificates of vote ultimately had a certificate of ascertainment attached to them. That's not the case here. These defendants never had a certificate of ascertainment saying that they were the actual voter, or the actual presidential electors. Again, and I'm not going to comment on whether it was lawful or not lawful, what those Democratic electors did in 1960 in Hawaii, but the other side's provided no authority that says what they did was lawful. They say the Hawaii precedent. Well, there is no precedent. There was a situation that happened in a trial court, and we've had no appellate review of it. We don't know what happened there other than what happened in the trial court. There was a recount ongoing at the time. The facts are wildly different. The lieutenant governor of Hawaii at the time, who was acting as governor, knew that the Democratic electors were going to meet and submit a slate of votes, and they essentially authorized them to do it. Again, I'm getting into facts, and I'm trying to stay away from facts because it's not appropriate to get into facts in this type of motion. Again, it's legally and factually irrelevant that someone else wasn't prosecuted 63 years ago under different laws, different circumstances.
But on this point, just so we can set bearings, in your research of this, has an elector or someone purporting to be an elector ever been prosecuted before?
I don't know, Judge. I don't know the answer to that.
But you haven't found one?
I have not found one. I have not found one. What I can say, I mean, if the court would like, that the archivist changed its procedures. The National Archives changed their procedures as it relates to receiving certificates of vote or things that purport to be certificates of vote after the 2020 election because of what happened. And now they've added an additional procedure to their kind of checklist of what we do when we receive these. And if it looks like something is fraudulent, they refer it out to their Inspector General's office to investigate. So just because it hasn't happened before, in our opinion, doesn't really have much effect on this case because we don't know those circumstances. Our position is that the motion should be denied. There's no provision of federal law that preempts Georgia from prosecuting election fraud. They pointed to nothing. The sets of law, the bodies of law, do not do the same thing. The general police power is reserved to the states, not the federal government. The Constitution expressly assigns power to regulate presidential elections to the states. And the Electoral Count Act does not in any way, while it may anticipate that multiple slates of votes might come in, it does not authorize them. They've pointed to nothing in the Electoral Count Act that says you can do this. It doesn't exist. It's not there. And so with that, I'll take any questions that the court might have. And anything else, rely on the briefs.
All right. Thank you, Mr. Wood. All right. Just solely on this issue, was any party wanting to submit supplemental briefing?
Yeah, Your Honor, I would like to rebut, if I could, just a couple of points.
All right.
I promise I'll be
Let's set a time limit.
Okay.
Why don't we just say about 10 minutes at the most?
I think that I can, although I am typically verbose, I think I can get that done, Your Honor.
He set a time limit on her.
Flaws that underpin virtually everything that Mr. Wooten just said.
Rebuttals.
First of all, the state just made our point for us, Your Honor. They said they get to decide who the real electors are, and because our folks weren't real electors, that all this consequence flows from that. That they don't get the protections of presidential electors. They don't get the federal protect. That is a fundamental misstatement of plain federal law. Under the ECA, unless the state meets the safe harbor, which there's no dispute they did not do in this case, both sets of electors are contingent, and the governor's certification upon which the state is relying has absolutely no authority for them to rely on that, for them to decide who the rightful electors are. That gets decided by Congress on January 6th, and not a moment before that when the state misses its state harbor. That is plainly the law under the ECA.
And so the two hypotheticals outlined to Mr. Wooten about 1159 and 10,000 cases, those are just unforeseen hypotheticals in the statute?
I think they are part of the reason the statute was recently changed, Your Honor, because I think there's been, if you look at the commentary and the experts on the ECA, There's been a lot of consternation about the fact that you could file a lawsuit, but that is in Georgia's control. What the ECA says is, hey, if you, state, want to set up a process that allows you to get to a final decision by Safe Harbor Day, then we'll let you do that to be conclusive. Georgia can control that process. They've set up a judicial process. If they wanted that done differently, Georgia could do that. They did not do that here. And so they have truncated the ability of the state of Georgia to get the benefit of the safe harbor. But no, that doesn't change what the law says about what the authority is or is not here, or who the real electors are not. Their entire theory, their legal theories, all flow from the fact that they believe they get to decide who the real electors are, when the Constitution is clear that only Congress gets to decide that. And when there is not a safe harbor decision and there's a dispute, Congress decides on January 6th. That's why the comment about, oh, well, Hawaii is different because they both ultimately got certificates of ascertainment. Well, none of them knew that on December 14th when they submitted their dual slates to Hawaii, so that can't possibly have any effect on the legal analysis here. The other critical flaw in the argument, Your Honor, is they fail to acknowledge what the Supreme Court has made very plain in United States Term Limits versus Thornton, and that is they don't get the benefit of traditional or reserved powers. They don't get the benefit because presidential electors are created by the Constitution, and therefore there is no 10th Amendment reserved power. There is no traditional police power that applies to them. They must articulate a specific constitutional delegation that authorizes them to act with presidential electors. They have not, and they cannot. The law does not support their description of what the appointment power is. We've gone through that. I'm not going to go through it again. We will certainly submit anything the court wants and our PowerPoint presentations. But that description of the appointment power as unbounded is entirely inconsistent with the law, with the Constitution, and with Supreme Court precedent.
And I didn't hear you address the In re Green case and the language that the state cited in that.
Yeah, I think we talked about that earlier, Your Honor. I believe the Green case is in the same bucket as the Chiapolo case, that it is grounded in the appointment power. I have to confess, I've read a lot of cases. I could get some of them confused, but I'll be happy to submit something on that, Your Honor. But I believe Green, Chiapolo, Ray, and maybe even Burroughs all are grounded specifically in the appointment power. The idea that Congress would say, we don't permit anybody to send dual slates, but we're going to talk about how we're going to handle it 5 different times in one section, defies any credibility. Their ability to count includes their ability to adjudicate, and they can't adjudicate what they can't count. They clearly are permitting people to submit it, whether they're mandated to or not, have a duty to or not, they're allowing them to. ACA is plain that they're allowed to, and that just really can't be disputed. Also, the idea that the law doesn't talk about contingent electors, well, yeah, we've come up with that term, but it clearly does anticipate that there will be some electors that are certified, for example, by the governor, and some that might be certified by the legislature, and here's how we're going to deal with that. There might be ballots and papers purporting to be ballots. So whatever you want to call that, Congress might call it purported electors under the language they have used. It doesn't matter. It's plainly addressed and allowed under the ECA, and that is the point. To the point we were making about In re Green and Chiapolo, Your Honor, the state cites Moore versus Harper. I think there's just a fundamental misunderstanding there. Nobody disputes that the state gets to act broadly in its appointment power. It's just that's not what it's done here. Same thing with Harper. They get to act broadly in their control over elections that is also specifically given to them under the Constitution. That has nothing to do with what the boundaries of those powers are and how far outside of them they are here. And I mean, I hear that, I've seen this in the other arguments, but it's very frustrating to have gone through at length multiple cites to precedent, multiple cites to statutes, multiple cites to all of that, and then have the state say, we cited no authority for this and no authority. If by no authority you mean the Constitution itself, Supreme Court precedent, and federal statutory sections ad nauseum, then yes, we've cited nothing. But if that is not what you mean, then we have cited all kinds of authority that countermands the authority they have cited, and they have not addressed the authority that we have cited. Let me check with my team just real quick and see if there's anything else we need to address. Okay. Thank you, Your Honor.
Thank you, ma'am.
And Judge, if I may just, there were a couple arguments that were raised in the PowerPoint that I don't know that they appeared in the brief, so we would request maybe 10 days to provide any supplement to those arguments.
All right, and any from the defense?
I think if they submit something, Your Honor, we'd like the opportunity to respond if we think it's necessary, since it is our motion.
All right, so if the state, we could have that by COB on the 15th,
Yes, Judge.
and we can set a reply to the reply, or sort of rebuttal, by, and I think at that point you're running into perhaps your break, but I think we could say by the 2nd. All right. Okay. I think we probably, hoping everyone packed lunch, I think we probably need to take our a bit of a noon break here. I'm wondering if we could be back and begin the next argument before we're looping in, I presume by Zoom. I don't know if the other co-counsel are joining us in person or by Zoom for the, what I was thinking would be some straightforward arguments on scheduling that they had raised, and then we can pause where we are and then resume. So my thought is come back at 12:45 and get started on the next argument. All right, let's do that then. We'll be in recess. Thank
Boy, how are you? Good to see you, buddy. No complaints.
Not only do we come back, we come back
You give it to all of us? Craig's the team. Right there, son. Try not to lunge on any of them.
No, I hear you.
So that would be coming to the Chris and Richard. Oh, you got
Yeah, there's what did you just do too? Perfect. Thank you.
They're like, ho, 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 ho. All right, so what are we going to do here? I feel all discombobulated. I ended the stream abruptly. I feel really forbidden. And now we get on this, and then they go and take their bagged lunches. Like, what's going on? Oh, shit. I muted the wrong frickin' thing. What's up, everybody? We are on lunch break. Lunch break. A sacked lunch. Remember when your teachers would say, bring a sacked lunch?
Diarrhea of the mouth.
All right, let's see what's going on. I heard Chad Dorman was in court. Chad Dorman hearing. Let's see what his dumbass had to say. He was in court today. I don't see anything from today. Or is this from a few days ago? Sacked lunch. Oh, a week ago? Is that what you all are talking about?
You felt like you He was just angry, generally speaking.
He was every day. Heard him. There wasn't a day he didn't yell at his wife and kids out there.
Was he in court today? Because I've seen
What would he
this.
yell?
All kinds of shit.
I don't know who said that. Who was it that said that? Sacked and packed. Was he in court today, or is this old? I don't think anybody's in court today. What else is going on? There's a dude that escaped from in Pennsylvania again. Philadelphia Industrial Correctional Center. What? I don't know how to spell Philadelphia Industrial Correction Center. Philly prisoner Gino Hagencotter escapes while on work detail. Gino Hagencotter, a 34-year-old inmate at Riverside Correctional Facility, was working a detail assignment in the orchard behind the Philadelphia Industrial Correctional Facility. 34 years old. He's 5'6". He's a little guy too. 5'6", 140 pounds, brown eyes and gray hair. This is him. Ugh, scary. He looks like a little Vito. Look. He looks like a little Vito. He's a little dude, 5'6", 140 pounds. He escaped. Hopefully they catch him soon. The U.S. Marshals are on his ass. So we're going to go back to the Trump thing after the break, but I might just leave this streaming because I got shit to get done. But I'm going to see if there's anything else going down. Another inmate. I guess this happens a lot. Breaking. Inmate who escaped in 2017 breaks free again. This is all being reported by Nick. Oh, it was it was a week ago. I did see that. Didn't they? Did they set a trial date for Chad Dorman yet? I don't see anything else breaking right now, but I did not know that Trump was going to be streamed live, so that's pretty interesting. We're going to be doing body cam Monday. We're going to be talking about Ruby Frankie Monday. Tonight we have another premiere, Idaho 4 premiere. We have another Idaho premiere tomorrow. And then we have a premiere on Sunday that is a special premiere. Let me show you the trailer from my special premiere. I just got it uploaded this morning. I've been a busy bitch. I've been a busy ass bitch. So let's take a look at the new trailer. This is a case. What? They want me to verify it's me to play a fucking video? They have the perfect timing, don't they? I want to share this case. This is a Florida case, and this happened while we were all enthralled with Idaho 4 last November. I'm just going to pull it up a different way.
Eddie screaming, and he's got my daughter by the hair and by the neck, and she just has like blood coming out of her mouth. And
oh my God! Listen to me. What happened? I don't know what happened. Her neck is cut. My daughter's neck is cut.
It was early Christmas morning, 2021. A Hernando County, Florida teenager was stabbed in the neck. Police records said the victim's boyfriend was the only other person in the room with her. Florida's 6th District Medical Examiner ruled the case a homicide. However, detectives never held a formal interview with the boyfriend, and prosecutors declined to file charges. Ariana Tarsensky's father, Eddie, her life was going well. She had just gotten a job at Hobby Lobby and just got her license 4 days prior to this incident. Ariana was celebrating the holiday with her family and her first boyfriend, Ramon Calderon Durst.
Can I just say something? Can we have a little back and forth real quick? Let's have back and forth. Go ahead. My life's over right now. What do you mean? You know what I mean. You see what the situation is.
I don't know what the situation is. I've been outside with you.
Okay. What do you think the situation is?
I don't know. I don't want to assume.
Do you see what I'm covered in? Please help me, man. Please help me. My daughter's taking... Oh, you want to just do one?
All right. Took the handcuffs off you? All right, listen, we're going to get you out of here. We looked into the case a little bit further, and we're not charging you with anything.
What?
We're not going to charge you anything right now. Okay? We're going to look into it a little further, make sure some things are the way they're supposed to be, so you're going to get out of here.
Eddie's screaming, and he's got my daughter by the hair and by...
That's coming up on Sunday, guys. That's going to be our premiere on Sunday night. I've got the body cam. I've got the dash cam. So get your hot cocoa, pop your popcorn, light your fire in your fireplace, because we're going to be going over this story to raise awareness, because they still have no answers. This just was in the news 2 days ago. 2 days ago. It's not an interview, but I am covering the case. So that's going to be Sunday night, guys. I mean, how can you have this guy all bloody and, oh, I know I love watching police interrogations, but the thing is, they didn't interrogate this kid. That's what's the travesty about it. So he was the only one in the bedroom with her. She was stabbed in the neck. And, oh yeah, Timmy. Let's cover Timmy. Good idea, Kendi. Timmy Ferreter. I have some documents. Hold up. Thank you so much for the reminder, Kendi. I can get this. I can clip it. And then I can put it up in a separate video. So let's do that. Let's do that. I have the full docs on Ferret. Motion for post-sentence release. He's trying to get out again. Idiot. Thank you, Mike Sanner. Mike Sanner just put an update up for us. Okay, let's get this up on the screen for your viewing pleasure. And I'm going to get informed so that I can clip this into a video. So never mind me. Y'all just follow along. Oh, this guy is such a douchebag. And then they lied about this Mazda dealership job. Like, we're going to do a little video out of this. Hold on, hold on, hold on. Defendant's motion for release on bond, pending appeal, and request for evidentiary hearing. He's got some nerve, let me tell you. Hold on, I've got to get the other thing, the letter from Mazda, so I can show you guys that. These people are a joke, I tell ya. Okay. All right, we've got the letter. Okay, so let's run through these court documents. This is the latest in the Timothy Ferreter boy in a box trial. Timothy and Tracy Ferreter locked their child in a box in the garage. We watched the trial of Timothy, and Tracy is expected to be on trial next year. She is in court next Thursday, or rather next Wednesday, for a hearing. So December 6th, Tracy Ferreter has a motions hearing in the Palm Beach County Courthouse. But this is on Timothy. So Timothy was convicted, he was sentenced, and now he's asking for release. The defendant appellant, Timothy Ferreter, through his undersigned attorney, moved this court for an order granting his release on bond during the pendency of his appeal. So he's appealing his sentence and he thinks he should get out in the meantime. On October 12, 2023, Mr. Ferreter was found guilty of aggravated child abuse, false imprisonment, and child neglect. On November 16th, the court granted Mr. Ferreter's motion for downward departure and sentenced him to 5 years in prison, to be followed by 5 years of supervised probation. The court ordered that 2 of the 5 years of probation be served on community control. Mr. Ferreter is 48 years of age and has no prior criminal record. Mr. Ferreter has lived in South Florida, Boynton Beach, Lantana, Palm Beach Gardens, and Jupiter for 18 of the past 23 years. He has lived in Jupiter since December of 2021. Mr. Ferreter has been married to his wife, Tracy, since 2003. They have been together since 1997. If Mr. Ferreter is released on bond, he will live with his wife at the home of Colin Zemirink in Palm Beach Gardens. Now, who is Colin Zemirink, you may ask? And that is where I come in handy with Google. We're going to see who Colin is. I have a feeling this might be Mr. Aussie. No, it's not. Who is Colin Zemirink? Do I want to know? I'm not accepting your cookies, Colin. Head of Industrial Manufacturing and Services. He has played a pivotal role in 100 engagements in North America, Asia, South America, Europe, and Australia. He's a supply chain analyst. He has a master's degree in industrial engineering and management from the University of Twente in the Netherlands. How does he know Timothy Ferreter? And why does he want Timothy Ferreter living with him? Oh, he has a mugshot. And they're asking, what? He was arrested in what? He wants to, you guys, what the fuck? He wants to be released as someone who has a mugshot? Oh, this is Tim Ferreter's buddy. What? Did Court TV show this dude's mugshot? He was born on 2/2/1971, 51 years old, white male. He lives in Palm Beach Gardens. He eluded the police? With sirens active? What? This guy's a criminal. And he wants to be released in his custody? Are these people idiots? Are his lawyers morons? Oh my God. I can't. What did he elude? What was he wanted for? Dude. Oh my God. We got to find this. He paid bond for them? Holy shit. This gets worse, guys. Oh my God. If you remember on day 3 of Florida versus Ferreter, Tracy was sitting next to this man. Many of us speculated that he was her attorney. He's the guy that was in court. Her attorney. Because he was taking photos and videos of evidence in court, attempting to capture timestamps for Tracy's benefit. It turns out he is not an attorney. He is a consultant for business operations. He also paid bond amounts of at least $50,000 for Tim and $50,000 for Tracy. What? Oh, there he is. Jammers, what's happening here? Oh, shit. And he's laughing. What is he laughing about? Y'all, I am shooketh. I'm shooketh. All it takes is one Google search of his name. OMG, guys. Who is this clown and why is he interested in this? Help. Help! What? Oh, shit. Okay, let's go back. If Mr. Ferreter is released on bond, he will live with his wife at the home. So his wife's living with this guy? What? Of Colin Zimmerink in Palm Beach Gardens, Mr. Ferreter has made plans for his employment upon release so he can provide for his family. Ferreter plans to work for Dream Outdoor Properties as a sales assistant in Jupiter, Florida. A letter confirming that Mr. Ferreter has been offered that position and describing his job responsibilities is attached to this motion. If for any reason the position at Dream Outdoors does not work out, Mr. Ferreter has also been offered a sales position at Mazda of Palm Beach. A letter confirming that Mr. Ferreter has been offered this position is attached to this motion. Additionally, they have letters from what? A large number of people that attended the sentencing indicate Mr. Ferreter continues to have a strong support network consisting of many individuals / criminals that reside in South Florida. Additionally, Mr. Ferreter has had a strong spiritual relationship with Father Chimindra Williams since 2012. Father Williams is currently a priest at the Holy Cross Catholic Church in Indiantown, Florida. Father Williams currently remains in regular contact with Mr. Ferreter. Father Williams was previously a priest at the All Saints School in Jupiter and at the St. Peter's Church in Jupiter. During his time at these locations, Father Williams had a strong relationship with Mr. Ferreter and his family. Okay, those kids never mentioned Father Williams. Mr. Ferreter was originally released on bond of $50,000. Thus, Mr. Ferreter was released on bond for more than 18 months prior to his trial. During that time, he complied with all conditions. Oh my God. This is crazy. And she's citing case law. The fact that Mr. Ferreter and his family lived in Spain for a short period of time in 2009 does not support denial of bond in this case. Mr. Ferreter lived in Spain due to a work commitment approximately 14 years ago. Third, the 5-year downward departure prison sentence imposed in this case is relatively short. Finally, there is absolutely no evidence in the record that suggests that Mr. Ferreter is a flight risk. Therefore, based on the fairly debatable issues Mr. Ferreter intends to raise on appeal and a consideration of factors laid out in Youngins, this court should grant him post-trial release. Accordingly, this court should set bond in a reasonable amount and order that Mr. Ferreter be released during the pendency of his appeal. Why does this dude, Colin, want him out so bad? Look at this shit. Dream Outdoors Properties. Mr. Timothy Ferreter, Whirlaway Road. Who lives at Whirlaway Road? This Colin? He's applying for jobs and using Colin's address. I still want to know what Colin was eluding the police. Why was he doing that? Why was he running from the cops? Look at this house. Oh, holy fuck. What? $2.5 million home? Mike Sanner, what's going on with these people? Who are these people? How do they... This is that dude's home? OMG. Guys, what are these people involved in? 2 sets of washer and dryer, 5 bedrooms, 7 bathrooms, 7,000 square feet. Somebody make it make sense. These people locked their kid in a box, and this guy wants to take them in. He's probably already taken Tracy in. She's probably basking by this pool right now with Colin. Look at the garage. Steeplechase subdivision. Look at the fucking garage. The garage is bigger than my home. Oh my God. This is so wild. I can't. All right, let's go back. Because we're going to look at this really quick. Wait, no, we're not. No, we're not. No, we're not. Hold on. We're going to look at the Mazda letter before we get back into the... Oh, I cannot believe this. This is so weird. Okay, here's the Mazda letter. Let's read through this. They sent this to attention Peter Burke, R.E. Timothy Ferreter. This is November 29th, 2023. Mr. Burke, this firm is counsel to Palm Beach Autoplex LLC, doing business as Mazda of Palm Beach. Due to WP TV's coverage, it has come to my client's attention that in support of Mr. Timothy Ferreter's November 20th, 2023 motion for release on bond, pending appeal, that certain documentation purporting to be an offer of employment from Mazda of Palm Beach had been submitted to the circuit court. Please be advised that such document is a complete and unequivocal forgery. At no time has Mr. Ferreter applied to Mazda of Palm Beach, let alone been given an offer of employment at the dealership. Moreover, the letterhead appearing on the document is incorrect, as it is nothing more than a copy and paste of a website graphic. Please be guided accordingly. Joshua Telkovitz for the firm. Shouldn't there be more charges for forging a document in order to get out of prison? Shouldn't he face charges? I am appalled at the nerve of these people and this Colin. What is wrong with him? So here's the letter where it says, thank you for taking time to interview with us. Here's the dream thing. Timothy, we are excited about having you join Dream Outdoors Properties LLC. Because look, they had to freaking sign it by someone. Look, HR, that's from real estate company. But this is from Mazda of Palm Beach. They literally, guys, copied and pasted it from their website. Look at November 13th. They wrote this to the judge. They wrote this to Judge Coates, Mazda Palm Beach, located at 2677 North Lake Boulevard. And look at it says North Palm Beach. North Palm Beach is happy to offer a position in our dealership to Mr. Timothy Ferreter upon his release on bond. Mr. Ferreter will assume a sales position at the dealership. The associated weekly salary is $250 plus commission. Most of our salespeople average $80 $100K per year, with possibilities of higher combined salaries between $120,000 and $200,000 annually. The dealership is open from 9 to 9 and schedules are developed monthly. Please note that Saturdays are mandatory work days for our sales staff. So, in other words, they're saying, oh, he has to work on Saturdays and he can't go back for work release. So if the judge wants to give him work release and be out during the week, he doesn't even want to go back on the weekends to jail. Mazda of Palm Beach offers benefits and vacation pay, which would be established upon accepting the position. Mark Caracas, Director of Sales and Development, with a phone number and no signature, but then this fake signature or thing at the bottom, banner at the bottom. Oh, man, this is not good. This is not good. Wow. If there isn't any more charges on this dude, this is a problem. Now, I want to know why he was eluding the police. And this would be Palm Beach County. Oh, you know what? We'll just go right to court documents, Colin. Palm Beach County Clerk of Court. And I bet there's body cam on this too that we can request. I mean, this dude really thinks he's going to house these criminals and pay their bond? Why? What is his investment in these people? Why would this dude pony up a bunch of money for them? I think he's got some explaining to do. What the hell's his last name? Colin what? With his $3 million house? Zemerink. Skittle-a-rinky-doo, skittle-a-rinky-doo. Another Colin. Why are Collins such douchebags? Sorry, Colin, you're a douchebag. Okay, here he is. Whoa. All of them are closed. So traffic, he wouldn't pull over for a traffic stop. 223 of 22. What was his deal? Let's see. Careless driving. Dismissed. Not that that's a big deal, but why would you run from the cops? Let's see this one. Bicycle in natural area? Not guilty plea, set for infraction trial. He had to go to witness Ian Sowers. Officer Sowers. Published photos. Found guilty. He had a jury trial for riding a bike. Okay, maybe this dude isn't a criminal, but he... Oh, I missed this felony. Oh, shit. He has a fucking felony. I'm like, oh. Oh, Lord. What is it? Felony. Probable cause affidavit. Fuck. It's a criminal probable cause. Oh, man. Guys. Flee and elude. Oh, we've got the probable cause. I love Florida. All right, we're going to read through this. Holy shit, guys. What shit bags these people are. I love these kind of lives, though, where we uncover all this stuff. It's so cool. Okay, let's go over to this document. Whoops. And this is Colin's arrest affidavit. Let's see what he was up to here. Okay. So this is the beginning of it. It says, this is in 2022. He lives on Whirlaway Road. That is his house. Colin Zimmerink. He's 6'4", 220 pounds. Married, Catholic. See that? Married, Catholic. What religion are you? I'm Catholic. He was born in Holland. And he's a consultant. For what? I don't know. Fleeing and eluding. Marked vehicle with lights and siren. On Monday, February 22nd, at approximately 10:41 hours, I, Officer McCrae II, was conducting routine patrol in my department, issued marked patrol vehicle facing east in the median in full police uniform in the area of North Lake Boulevard and Cypress Hollow Drive in the city of Palm Beach Gardens, Florida. I observed a red convertible Ferrari. Oh my God. The typical midlife crisis motherfucker. I observed a red convertible Ferrari traveling west at an excessive speed, which was later paced approximately 90 miles per hour in a 50 mile per hour zone in the middle through lane. This vehicle had its convertible top down, allowing me to easily identify the driver to be a white male with gray hair, wearing a gray shirt with blue lettering. This vehicle attempted to stop abruptly in the middle lane of traffic upon sight of my marked patrol car, causing a traffic hazard to other motorists in the area. I then made an upturn to travel west on North Lake Boulevard. Change over 2 lanes to the left, failing to signal. I initiated my lights and sirens to conduct a traffic stop on said vehicle just east of North Lake Boulevard and Ballinile Drive. Said vehicle failed to obey my lawful traffic stop by fleeing and continued at a high rate of speed before making a left turn into Steeplechase community. He freaking went home. He hightailed it home. He has kids? And Tracy's living there? What?
What?
While entering Steeplechase, Armando Sanchez, who is a security guard for the community and was identified by his Florida driver's license, flagged me down in reference to this vehicle and advised he witnessed the vehicle turn east onto Whirlaway Road at a high rate of speed and knew this vehicle's owner to reside at 5589 Whirlaway Road. Upon arrival to 5589 Whirlaway Road, I activated my department-issued body-worn camera. I am going to request this. I then observed the male whom I observed operating the said suspect motor vehicle standing in the driveway with his arms folded across his chest. I made contact with the driver, who was later identified by his Florida driver's license as Colin Zimmerink. I detained Zimmerink with handcuffs, which were checked for proper spacing and double locked. I asked Mr. Zimmerink why he fled. He replied, "I'm sorry. I must have freaked out." I was able to confirm vehicle information regarding the red Ferrari, California, bearing Florida tag, Colin. #Colin. Ah! What a fucking douche. His license plate is #Colin. Come on. Colin Zimmerink was operating a vehicle upon a street in Florida. Colin Zimmerink, in the closed garage. Sorry, he closed the damn garage too. Colin Zimmerink, knowing he had been directed to stop by a duly authorized law enforcement officer, willingly fled in a vehicle in an attempt to elude a law enforcement officer. I, Officer McCrae, a police officer in Palm Beach Gardens, was in an authorized law enforcement patrol vehicle with agency insignia and other jurisdictional markings, predominantly displayed on the vehicle with sirens and lights activated. The defendant did unlawfully and willingly refuse to stop his motor vehicle in compliance with said directive. I did read Zimmerink Miranda warnings from a department-issued prepared text. Zimmerink was in possession of Ferrari car keys at the time of my arrest. Zimmerink's keys were turned over to his wife while on scene. I find probable cause to arrest Colin Zimmerink for fleeing and eluding with lights and siren activated in violation of Florida of FSS. Zimmerink was transported to Palm Beach Gardens Police Department for processing and later to the Palm Beach County Jail without incident. I'll be requesting that body-worn camera footage. Yes, I will. Yes, I will. This is bananas. Bananas. So Mr. Ferreter has lied and said that he had these job offers, which he didn't. He never had any job offers. He lied. And they forged letters to the judge in this case. So hopefully the judge will not take this sitting down. You know, Mr. Psh, psh. Hashtag Colin. Unreal stuff. All right, let's go back to his frickin' case thing. So that's defendant bonded. Let's see what happened with this. Not guilty plea. Released to this county only. He should have never been released. He eluded the police. Make him sit there. Make him sit there. You elude the police. You don't get to get out on bond. That's bullshit. Plea conference. Continued. Let's see when this was finally... Disbursement, $3,000 from Colin Zimmerink. That's nothing to him. Status check. Let's see. Pretrial diversion. He got a diversion. And he didn't even have to be there. State announces whatever. DPA. I don't know what that means. But a diversion means it'll come off his record, guys. So literally, they cannot use this against him in the Ferreter case. You hear me? I don't think they can use this against him if, you know, Ferreter's asking to live with him and stay with him. I don't think they can use it because he had a diversion. Let's see if we can read that diversion. Deferred prosecution agreement. Let's see what this says. He got frickin' community service for a felony. Wow. So this is what happened to him. You will remain at liberty without violating any law. You will undergo, or no, that's not even checked. You will pay $200 cost of prosecution to the Palm Beach County clerk. And he had to do 25 hours of community service. And that was in 2022. And I'm sure he probably did that. And it's off his record now. Unreal. These people get scathed away. Hopefully they get in trouble for these fake documents. I think they should anyways. I think the fraudulent letter, yes, at the very least to be denied, but then also I think they should press charges on these people. I mean, look at this house. I mean, what is this guy up to? $3 million. I mean, this is... I just don't know what people do to make that kind of money. I don't understand. How does this guy own a $3 million house? I know a lot of people own houses like this, but he's friends with someone who would lock their kid in a box and then he bailed them out. So what kind of person is he? Every single one of these people should be looked at. It's just like the Vallow case. Every single one of those people that were associated and believed Chad Daybell should be looked at. Every single person that wanted Tim and Tracy Ferriter out of jail should be looked at. That priest should be looked at. What are these people doing in their Catholic charities in other countries? I hate to say that, but damn, it makes one wonder. How humble is this? How humble is this, I ask? This is not humble. This is the guy who wants Timothy Ferriter out of jail and said he can live with him. This is his house. And that's where Tracy Ferriter is residing right now. Disgusting. Absolutely disgusting. Thank you guys for that update, though. Thank you, Kendi, for reminding me of that update. Appreciate that. Let's get Trump back on the screen because I think they're going to be back shortly. And I've got to go get something to eat. I haven't eaten yet today. And I'm starting to not feel good. So I got to get something in my stomach. But I'm going to get this back up for all of us to watch. But I cannot believe what I just read. I can't believe what I just read. I am in shock. You guys let me know what you think of this. This is bananas. And if you didn't catch it all, rewind. It's very, very interesting to say the least. To say the least. And I want to share that trailer again. This is going to be Sunday night, you guys. Join me Sunday at 7 p.m. We're going to premiere this. We're going to have body cam, dash cam, and the story on this Florida girl who was stabbed in the neck last Christmas. And no one has been held accountable.
Eddie screaming, and he's got my daughter by the hair and by the neck, and she just has like blood coming out of her mouth. And
Listen to me. What happened? I don't know what happened. That's her neck is cut. My daughter's neck is cut.
It was early Christmas morning, 2021. A Hernando County, Florida teenager was stabbed in the neck. Police records said the victim's boyfriend was the only other person in the room with her. Florida's 6th District Medical Examiner ruled the case a homicide. However, detectives never held a formal interview with the boyfriend, and prosecutors declined to file charges. Ariana Tarsensky's father, Eddie, her life was going well. She had just gotten a job at Hobby Lobby and just got her license 4 days prior to this incident. Ariana was celebrating the holiday with her family and her first boyfriend, Ramon Calderon Durst.
Can I just say something? Can we have a little back and forth real quick? Let's have back and forth, right? My leg's open right now. What do you mean? You know what I mean. You see what the situation is. I don't know what the situation is. I've been outside with you. Okay. What do you think the situation is? I don't know. I don't want to assume. Do you see what I'm covered in? All right, please help me, man. Please help me. My daughter's sick. Oh, you want to just do one?
All right. Took the handcuffs off you? All right, listen, we're going to get you out of here. We looked into the case a little bit further, and we're not charging you with anything.
What?
We're not going to charge you anything right now. Okay? We're going to look into it a little further, make sure some things are the way they're supposed to be, so you're going to get out of here.
Eddie.
Have any of you guys heard of this case? It happened here in Florida last Christmas, and I think, here at least we were all enthralled with Idaho 4. We had Brian Koberger's arrest 5 days after this happened. I know I didn't hear about it until a couple days ago. Fox Orlando, I believe, is digging into this for the parents and helping those parents get the word out, because this kid has never been questioned. We're going to watch his hour-long body cam, or interrogation cam, I should say. And we're going to watch the dash cam that's an hour long of him sitting in the cop car. So get comfortable. It's a little over a 2-hour premiere, but I'm looking forward to sharing that story with you guys. It's disturbing to say the least. This happened in their home. In their home. And the autopsy says that she was stabbed by others. So tune in Sunday at 7 p.m. Eastern Standard Time with live chat. Mike Sanner, I think if the host gets arrested or convicted of a crime, the state can nullify ability of guests to live there. Well, that's the thing. He got a diversion. So I'm pretty sure he did his community service and then it was dropped. So I don't know. Can they hold that against him if he did a diversion plan? I don't think they can. But this dude lives in a $3 million home. Tracy Ferreter is living there, and she wants to live there with her husband. And then they lied about the job offers to make it look good. I think that they just need to go to jail for life, because they clearly are just playing games with the justice system. And if this judge doesn't do anything about this, wow. Bye, Global. Enjoy your lunch. Unyo, CEO. CE Unyo. They should be wrapping up their lunch shortly in this Georgia case. Oh, a new offense. Yes, if they can figure out where these documents came from. See, what they should be doing, Mike, is subpoenaing their records, because this dude was also seen in court taking pictures of evidence. And then they need to see who faked these letters. Who saved the fake letterhead, for Mazda. You can't just do that. How can you just send a fake letter to a judge and get away with it?
Roberta.
How do you kill someone and get away with it? Here we go. We're back.
Now, that's devolved into a bunch of different types, political, commercial, and other speech. But as a floor, the First Amendment says that the government cannot do that. And that any attempt by the state to restrict political speech, when we're going to look at it, has to be reviewed under a strict scrutiny analysis. Now, the strict scrutiny analysis is what ends up meaning that when most courts look at this, all of the on political speech, the attempts to criminalize, the statutory restrictions are shut down. This is a little bit different from intermediate scrutiny. Intermediate scrutiny is what they looked at in Alvarez. And in Alvarez, which is cited, is the Stolen Valor Act case. And in Alvarez, the defendant in that case said, listen, I'm a Congressional Medal of Honor winner. Lie. Absolute lie. And the Supreme Court looked at it and they said, well, yeah, it's a lie. But the First Amendment, even under intermediate scrutiny, is going to say, we're not going to criminalize that activity. We're going to allow him to say that. So even under intermediate scrutiny, there's tons of protections, but then it gets ratcheted up when you're dealing with political speech, which is what this is. And the Eighth Circuit, again, quoting from United States Supreme Court cases, said that when you go ahead and you apply strict scrutiny, there is going to be almost no amount of fine tailoring that a government can do with its prosecution or a statute that can override the overwhelming free speech protections of speech. And they say that because a criminal prosecution of political speech is particularly dangerous, quoting Judge Breyer, and consequently it can easily result in censorship of speeches speakers rather than their ideas. So what they're saying here is they are saying, listen, I get it. There's an interest in having some type of restrictions on the manner of speech that we have on elections. We want to have good outcomes here. But we're going to weigh that against the chilling effect of restricting that speech as it relates to the elections. And the Constitution and the Supreme Court have said, we're going to put up with a heck of a lot of speech before we quiet it, because the result of telling somebody or prosecuting somebody for saying something about an election that a DA disagrees with is terribly, terribly dangerous in our society. And we're going to potentially shut down all of that speech with regard to dissonant or dissenting views we don't agree with. I'll get the word out.
If there's a dissenting opinion,
thank you.
The case is the kind of the window setting and
Yes.
or scene setting rather, and these broad principles you're referring to in these cases. Most of these, aren't they facial challenges where they're striking down a statute in its entirety that is solely and very obviously targeting speech?
Well, I think that that's right, but I think that you can attack the indictment here and the statutes under which it's charged upon just within the four corners of the complaint. Again, we're going to accept everything in there that they say is true, but even when we're accepting everything that they say in there is true, it doesn't reach up to these, and they are broad principles. But
just so I'm clear,
yes.
what lane we're in, though.
Yes.
The argument isn't like many of these cases that we read about and that establishes principles that the fraud statute
right
has to go away. It's as applied here. It's unconstitutional.
As applied here is unconstitutional. Yes.
So we have to get over that first hurdle of whether we can make an as applied challenge.
161020 should be attacked facially.
Okay.
Haley makes that hard, but I think that it should be attacked facially. That probably is, the rest of them would be as applied. And then the next thing, Your Honor, again, kind of going, I'm sorry.
No, go ahead.
Oh. And once we decide that this is, I'm sorry. Once we decide that it is political speech, both the state and the legislature have a duty to do two things. They have to show that there is a compelling state interest with regard to what they're doing. And they also have to show that the restrictions on the speech are as narrowly tailored as possible.
That's what I'm getting held up on again.
Yes.
Because that whole line of analysis, the legislature has nothing to do with this, right? Because the statute is what it is.
Right.
So in terms of whether it's been narrowly tailored or whatnot, if we're as applied, that's not really coming in, right?
No, you're right with regard to the attack on the statute, but what I'm getting at is the prosecution here, and the point being with regard to all the statutes that are at issue and everything that they're prosecuting is that as applied, none of them can stand because, and I'm about to get to this, because there is counter speech available. And the counter speech that's available, and that's discussed a lot in Arneson, what the courts say is, listen, if you have debate and you have false speech, the Supreme Court has said, listen, the remedy for speech that is false is speech that is true. This is the ordinary course in a free society, and the response to the unreasoned is the rational, the uninformed, the enlightened, the straight out lie, the simple truth. And what happened in Arneson is that the court said, listen, if you say something false with regard to this ballot referendum, somebody else is going to pick up the ball and say something true. And you're going to have an invigorated debate about those issues, and that'll wash out in the election. What do we know about this case? Every single thing, every act, every count that's talked about in this case was published in real time. Every single thing was very, very hotly contested. There was more than enough, a ton of counter speech. And what happened? What happened is the court challenges were resolved. Joe Biden was put into presidency in January of 2021. And we were done.
But I don't know if that legally makes a distinction, because if, as the state's theory as alleged had succeeded, you wouldn't then say here, I would have presumed that a prosecution is now greenlit under these same principles.
Under these same, I'm sorry.
If it's violating free speech regardless,
right.
It doesn't matter whether it was successful or not.
No, it doesn't matter whether it's successful. No, that's exactly right. All I'm saying is that part of the American experience is saying, listen, we're going to allow, it doesn't matter whether it's successful or not. Absolutely right. But what I'm saying is that the counter speech here that was available led to a result that apparently the state wants. And the counter speech led to robust debate, court cases, and you got a result. And that is what the framers were trying to protect. That's what Arneson was trying to protect. That's what the United States Supreme Court is trying to protect in virtually every single case that they talk about. And I've noted here that when you look at the various cases, and I've cited a ton, these are a hand, I mean, you can cite Supreme Court cases and First Amendment cases all day long. But in all of these cases that the Supreme Court raises when it relates to political speech, it is almost invariably going to fall out on the side of let the speech occur. Even if it's false, even if it's fraudulent, when it's in the course of an election, and especially a presidential election, and especially when you're going to have people on the other side going at it hammer and tong to figure out what is the truth.
When you say even as with fraudulent, do you mean even if false?
Even if false, yes, okay. Excuse me. Even if false. And the Supreme Court has come again and again and again and said that this type of speech, we're going to protect it even though it's false. And the state here in its indictment, the entire premise is, well, what you're saying is false. What you're saying is wrong. As of December the 3rd, when you have a result in the election, you ought to have known that Joe Biden was the winner. And because you said Joe Biden's not the winner, and because you filed a lawsuit and you had electors go and vote, and because you got on TV or did a tweet or came up with a legal theory, we want to put you in jail. That is anathema to our history, and it's anathema to the First Amendment. And I also cite cases here with regard to Georgia that are in accord. And, you know, Your Honor, before I kind of jump ahead, we talked a little bit about whether resolution is ripe. The Georgia Supreme Court, in a series of cases, have said that even if you have an as-applied challenge, you need to decide that case up front when it involves a First Amendment constitutional challenge, maybe not the same with other constitutional challenges. It also says that the court can consider a demur based solely on the state's averments, and that's all we're asking here. We're not asking for anything else other than what's in the four corners of the complaint. And so, taking all that, and I've truncated it quite a bit, but if you look at the cases, if you look at what's in the indictment, this isn't close. The defendant's statements and actions here are challenging the processes of the 2020 presidential election. It is political free speech. Once we know that it's political free speech, subject to strict scrutiny, the state tries to impose a viewpoint restriction on the defendant. You did not accept that Donald Trump won. And the entirety of the indictment is focused upon punishing defendants for that speech. And the state cannot show that the prosecution is narrowly tailored or that any of the statutes in the indictment are narrowly tailored especially when you have counter speech here that is available. And the First Amendment absolutely precludes any of the state's claims here. And I think one thing that I wanted to, hold on one second. All right, got it. Is we are in the throes of this, right? I mean, it's hot, it's emotional, it is something that is topical. And we think this is the first time America has ever gone through this process. It's not. It just is not. I was down in Florida in 2000 for the recount of the Bush versus Gore election. That resulted in the Secretary of State, remember the criticism she got, the Attorney General of Florida running around, decisions of the Florida Supreme Court, hotly contested. Is this ballot fraudulent? Is that counting fraudulent? It goes up to the United States Supreme Court. It lasts until almost January of 2001, about as long as this challenge lasts. And the Supreme Court, in a decision that a lot of people roundly criticize, say, this is the result. It's over. President Bush did not indict President Gore and his supporters for making those challenges. That was their political speech, and it resolved through the courts and through the political process as it should have. And when I'm thinking about, when else did this happen again? What happened in Georgia? It's kind of a history buff type thing, but we probably have all heard that in 1946 or 47, you had the elected governor of Georgia die before he got into office. It's called the Three Governors Controversy. And at that point in time, the Georgia General Assembly said his son, Herman Talmadge, we're going to make him governor. The duly elected lieutenant governor said, no, I get to be governor since I was duly elected as lieutenant governor. The sitting governor, Ellis Arnold, said, I'm going to hang around and I'm going to be governor. The Georgia Supreme Court weighed in, allegations of fraud, allegations of false statements, allegations that this just ain't right. And the Supreme Court said, well, it's going to be the lieutenant governor. But the members of the General Assembly that said it was Herman Talmadge, they didn't go to jail. Herman Talmadge didn't go to jail. Ellis Arnold didn't go to jail because they were advocating for a position that got worked out through the political process. In 1876, this is probably one of the craziest ones, Hayes versus Tilden. This led to the enactment of the ECA. Tilden was the popular winner. He was one vote shy in the electoral count, and Congress disallowed that one electoral vote from Oregon. They then didn't know who it was. At least according to the research I've done, this almost led to a second civil war. You have Congress put together a 15-member panel to figure out who's going to be the president, and it ultimately gets decided in a hotel room. Nobody went to jail. Very recently in Georgia history, the Kemp versus Abrams governor's election. Stacey Abrams said Brian Kemp didn't win. He illegitimately won. The election was based upon voter suppression. Numerous lawsuits won. She lost every one of those lawsuits. Stacey Abrams wasn't prosecuted, nor should she have been. Al Gore, Abrams, Kennedy, Tilden, Talmadge, members of the General Assembly, they are not prosecuted because what they were doing, even though they were pointing fingers back and forth saying, you're committing false statements, I'm the governor, you're the governor, I'm the president, no, you're the those came out in public, and they were hotly contested, and the First Amendment protected all of that speech. But once we start punishing people for taking the positions and challenging elections, I've challenged lots of elections in 25 years of practice. I've been involved in tilting at a lot of windmills. Once we start saying that you are going to go to jail for doing that, Those types of challenges are going to dry up. And that is precisely why the First Amendment and the Supreme Court have said you can't do it. And to get to a question that Your Honor asked earlier, when has this ever happened in our history? Didn't happen with Tilden and Hayes. Didn't happen with Jefferson and Adams. Didn't happen with Bush versus Gore. Didn't happen with Kemp versus Abrams. This is it. This is the first time that a prosecution of this type has been brought in this country, as far as I'm aware. And I heard my friends on the other side said they're not aware of one either. And the reason that these lawsuits, and that's a due process problem, but the reason these lawsuits haven't been brought is because the First Amendment says you can't bring them. We're going to allow the discourse. We're going to allow the statements, even if they're false, because somebody's false statement is another person's truth. And we might be able to prove something down the road. We might have this argument, but once we start letting the winners put people in jail, we're done. We are done. And that, our framers said, we're not going to allow. That is what the Supreme Court said during the civil rights movement, when people were making, you're violating the peace. You're saying something that we disagree with. You are making statements about these types of civil rights issues. You got to go to jail because you're standing on a public piece of property and you can't be there. The Supreme Court repeatedly says no. Whether it's your action, your petition to government, your speech, we're not going to allow the state to come in and say, you go to jail because we disagree. It is about as strong a presumption. It is about as strong a piece of law that we have in this country. And again, the reason we've never seen it before is because this is unprecedented. We can have all kind of disagreements about candidates, all kind of disagreements about policy, whether or not we think that what they did was morally right, good, bad, or indifferent. But we don't jail people over this in this country. Your Honor, and then very last thing I'll say is I think we especially don't jail people when they go and they give their statements to their elected officials and say, hey, I see a problem. Will you guys look into this problem? I see a concern. Will you look into the concern? That's the people you're supposed to go to. Go to jail, says the state. No, I say, and no, says the First Amendment. Thank you, Your Honor.
Thank you, Mr. Nolowitz.
Your Honor, may I address one specific point that I raised in the motion? Good afternoon. I do not intend to reiterate anything that's already been said by co-defendants counsel. He did a phenomenal job. I just want to make certain that the record reflects that we, that is President Trump, is suggesting to the court that your persuasive authority in the order that you entered in the matters of Chesbrough and Powell, specifically finding that the First Amendment as applied could not be done pre-trial, that Georgia precedent barred such a challenge, that you reconsider that as the authority. Instead, take a look at the case that I have cited, as well as has been cited by co-defendants counsel. That's the Hall case.
So in the Hall case, I think it was maybe only 3 or 4 sentences, but there was an aspect of that where the state was willing to say these are the facts. And that gave the Supreme Court something to play with.
True.
And so Mr. Nolowitz here says, we want you to apply it just based on the indictment. Where do you fall there?
I believe that if the state wanted to stipulate the facts that are clear, we would be willing to do that. They've not indicated any desire to stipulate anything. I believe you can do it simply on the indictment and the accusationary facts, those that are alleged. I think that's what the quote that I used from Hall indicates. You take the facts as alleged in the indictment throughout the RICO count. And when you do that as applied constitutionally with the First Amendment, you find that it violates free speech, freedom of petitioning, all the expressions that the First Amendment is designed to protect, and therefore the indictment needs to be dismissed. I'm saying you can do that pre-trial. If the state wants to stipulate to certain facts so that we actually can have this issue drawn in a clearer fashion for the court, we're more than willing to do that, but they don't need to. The accusation, the indictment alone is sufficient, and I think that's what Hall indicates. And I'd ask you to reconsider that particular part of the order. Thank you.
All right, thank you, Mr. Sadow. Why don't we go ahead and begin with the state's argument, and we'll see where we land. I know we had some other counsels stepping in at 1:30 around there. But maybe, Mr. Wooten, if you're taking this argument, we can pick it up right there with the Hall case, which was not one any party raised at the outset, but it certainly seems on point on this issue.
Judge, I just would request to be able to screen share. I don't think I've got the
yeah. All right, so we need Mr. Wooten and then
Thank you, Judge. And I will just jump right into Hall, Judge. As you pointed out, state's position is that Hall does not apply here. It was an as-applied challenge. It was taken up prior to trial, but as the court pointed out, there was at least some set of facts that was not in dispute. So not only, and as the court indicated, the state indicated what it believed the facts would be, and that was part one, but also the defendant did not contest those facts. And as the court pointed out in its order on the prior hearing on this issue, all of these facts are very, very, very contested. You can look
but
at.
I think what I heard was Mr. Sadow and the defendants here saying that just for the purposes of an as-applied challenge, they would be conceding the facts as laid out in the indictment. Yes. Perhaps not the part where it says everything's unlawful, but the facts as alleged. And then I know this was a 4-3 decision, I know, and so there was a vigorous dissent, but there's the statement in here where Justice Sears appears to say that as-applied challenges should be allowed pre-indictment. What do you make of that?
Well, Judge, I think you hit on something important, which is that if they're not willing to stipulate to all of the allegations, the intent requirement, the unlawfulness, all of it, you can't stipulate to some of the facts that don't establish the offense and say, let's make a decision. I think that's not congruent with Hall. I think in Hall there were facts that were stipulated to that, but for the constitutional challenge, established the essential elements of the offense. And then the examination was able to be made on that limited set of facts. And so here, I mean, as an example, let's take a false statement. I think that they would have to stipulate, and not, again, our position is that they can't stipulate just for the purpose of this argument. If the fact is stipulated to, it's stipulated to in the entire matter, is our position. They'd have to stipulate that for a false statement, that the statement was false, that it was within the jurisdiction of a department or agency of state government, they knew it was false, going beyond just the allegations in the indictment, going to, things that they've indicated in their pleadings are required for a conviction. They'd have to agree that they knew that those statements would come to the attention of a department or agency, et cetera. So I don't know that they're willing. To me, that sounds like a guilty plea.
Well, let's pause there for the purposes of an as-applied First Amendment challenge. Mr. Nolowitz, any thoughts on what facts? If we're just looking at the four corners plural of this indictment,
right?
What facts are to be stipulated to or agreed to?
Well, I mean, I think he's right. I'm not going to stipulate the veracity of the facts for all purposes going forward. I think
that's just for the purposes of an as-applied First Amendment challenge.
Purposes of the as-applied First Amendment challenge.
That everything in here is alleged.
Everything in here. I mean, again, we're not stipulating to it for trial or for evidence therefore. But if you were to look at everything in that indictment, it's saying just like on a civil motion to dismiss. We're going to take as true everything in there. It doesn't stand under a First Amendment.
Which you just your general demur framework, right? Yes. Mr. Sadow, is there anything you wanted to add there?
I would echo that position and have done so in my motion itself, indicating that for purposes of the First Amendment as applied challenge, it's undisputed as to the allegations of vermin in the indictment.
Okay, Mr. Wooten, back to you.
Judge, Hall does not say that the defendant in that case stipulated for the purpose of an as-applied challenge. It says that they did not contest the facts, period. So our position is that you don't get to, stipulate to the facts here, but then contest them here. We do not. I heard from the other side you doing a demur, but this is not a demur. This is essentially a plea and bar based on a constitutional challenge. It's not the same thing. And to be clear, in a demur, the other side is not stipulating that the facts are true. The court is taking them as true and making its determination as to whether or not the indictment is sufficiently pled. So our position is that there's no such thing as stipulate for the purpose of just this. That doesn't do it. That they would have to stipulate, again, not just to what's alleged in the indictment, but the proof that would be shown at trial, because an as-applied challenge looks at more than just the indictment. It looks, that's what Your Honor exactly pointed out in your initial order on this, is that you can't go just by the indictment, and in Hall they don't go just by the indictment. There are some additional facts that are stipulated to. And so I don't think that works. The state's position is that approach does not work, that the court still is not able to make a determination, even if they stipulate for the purposes of that motion that these things are true. We don't think I don't think that's the thing you can do. I don't think you can say, we're going to halfway stipulate. Either you do or you don't. Either the fact is stipulated, it is a fact established in the record as true by stipulation, or it's not. It's not a thought exercise. And in Hall, they agree that the facts are true, unequivocally. That's it. And so the state's position is Hall does not apply here because that is not what's happened here. When we move to the other case cited by Mr. Sadow, that's State v. Davis. He cites that as precedent. That's a facial attack. And as the court well knows, a facial attack is presumptively ripe. The argument in the facial attack is that it could never be applied constitutionally, so there's no need for a development of a factual record. So we agree with the court in its first order on this issue that these issues are just not right. There's no facts in the record as it relates to, there's some facts as it relates to some collateral issues, bond revocation, et cetera, but there has been no testimony under oath, no evidence, no exhibits admitted. There's no facts in the record. And so the court cannot make the determination at this point. I do want to hit on a few things, just bigger picture. We heard from the other side these grand statements about this is a prosecution of political speech, this is a prosecution of expression, this is a prosecution of association, petition, etc. That is not true. And the indictment tells you so. This is a prosecution for violating the Georgia RICO Act, individuals conspiring to participate in a pattern of racketeering activity while associated with a criminal enterprise. It's a prosecution for solicitation and violation of oath of office, false statements and writings, impersonating public officers, and the list goes on and on. Some of these are crimes involving expression. Some of them are not. Conspiracy is not a crime involving expression. It's a crime involving a corrupt agreement. And the crimes that do involve expression are specifically, we have specific authorization from the Georgia Supreme Court and the United States Supreme Court to prosecute that type of speech. And again, looking at Alvarez, the First Amendment does not protect a few historic categories of speech, including speech integral to criminal conduct, fraud, speech presenting some grave and imminent threat the government has the power to protect or to prevent. And Haley, as the other side pointed out, again, holding that 1610-20 is constitutional on its face. And so I bring this up to say that, I'm going to go back 2 slides, even if any of these issues are right, as a general matter, the defendants aren't telling the court what they want it to do, because you don't get to come in and just say the prosecution is unconstitutional. That's not how a constitutional challenge works. What statutes are unconstitutional?
It's how an as-applied challenge works, though.
Well, they're not saying, Judge, which statutes are being applied in an unconstitutional way. I mean, I guess we've heard all of them, but we haven't seen any analysis in the briefing or in the argument of how each specific count is applied unconstitutionally, has that criminal statute applied to it unconstitutionally. And so the state's position is that if the court's willing to entertain that argument, we'd ask that you make the other side reduce those arguments to writing, give us the opportunity to respond. They weren't in the briefs. And so I don't really know how we can respond to a blanket constitutional challenge that doesn't have any specifics, doesn't talk about statutes, doesn't analyze specific facts. There are no facts in the record, of course. But we don't get that analysis of exactly how each of these counts are being prosecuted in an unconstitutional as-applied way. It's just not there. We heard from the other side that this is the first time a prosecution of this type has been brought, that it's unprecedented, and that may be true. But this is the first time a criminal enterprise has gotten together and tried to overturn the results of an election. So I don't think that's a particularly persuasive argument, that this is the first time a case like this has been brought. There's going to be a first time a case under any statute or any situation is going to be brought, and that doesn't make it unconstitutional. And again, Judge, I promise I keep it brief. Our position is that these issues aren't right, that the speech or the other expressive conduct that forms the basis for the charge is not protected by the First Amendment. The U.S. Supreme Court has told us that over and over again. The Georgia Supreme Court told us that specifically as it relates to 1610-20. And they're just not sufficiently particularized. As the court pointed out, it's like, is this a facial attack? Is this an as-applied attack? We bounce back and forth, and the state just can't meaningfully respond until they've identified specifically what is being attacked. I'll take any questions. Other than that, nothing further.
Thank you, Mr. Wood.
Thanks.
Very briefly, Your Honor, again, with reference to the Alvarez case, the Arneson case talks about it and says that, yeah, these certain types of false speech we're not going to give protection to under an intermediate level of scrutiny, but once it gets involved in political speech, yes, we do. The First Amendment covers them. The other thing, just 2 quotes. A prosecution motivated by a desire to discourage expression protected by the First Amendment is barred by the U.S. Constitution, and it must be enjoined or dismissed, irrespective of whether the challenged action could possibly be found to be unlawful. That's in our brief. U.S. versus PAG, 965, Fed 2nd, 848. Freedom of speech is protected not only against heavy-handed frontal attack, but also from being stifled by more subtle government interference, such as via post hoc prosecutions for political expression and activities under the guise of enforcing general criminal prosecutions. That's in our brief. And they have not been addressed here. It is staggering to me, that the state would stand up and say, we accept every allegation for the purposes of this indictment. We'll accept them all as true. And they can't defend it under the First Amendment. Where in there is there non-political speech? How are you defending this? If everything you say is true, it's ripe for decision. That's what Hall says, and they're not defending it. One thing I wanted to point out, and I should have pointed out in my original argument, and it's in our brief as well. All this is in our brief. They decided not to respond to it. It's in our reply brief too. Is the state has looked at, and this goes to the unprecedented nature of this. The state is saying, listen, you have violated the election laws of the state. You are interfering with the way in which presidential electors are chosen. Voter challenges are made. There's a place called Title 21 of the Georgia Code, 600 annotated pages. I looked at it. I've read it. I know it. 90 sections talking about prosecutions, felonies, misdemeanors. That code, those actions that the General Assembly put together to ensure that we have free and fair elections in this state, doesn't make its way into the indictment. Not one place. Rather than looking at the state election code, they turn to Title 16, RICO, lying to officers. And they sit there and they try to mold these other statutes into a crime related to the elections of this state. And it's a bad fit. And it's a bad fit for all the reasons that we have said. And had the General Assembly wanted to prosecute the types of things that the DA is saying, it probably would have done so. It would have done so in the election code. And had it done so, I'd be sitting there saying, that's unconstitutional. Thank you, Your Honor.
Your Honor, may I address? Again, I will be specific. I've taken another look at Hall, and I searched for the word stipulate. It doesn't exist. Hall had nothing to do with stipulations. It had to do with a determination to be made on the record that was presented to the trial court. In fact, the opinion points out, because this matter is being reviewed following the trial court's denial of Appellant Hall's motion to quash the accusations against her, the underlying facts have not been fully developed. The state represents to the court, and then it talks about what the state's representations are. It does not speak in terms of what the defendant, Hall, stipulated to. As I said, it's not even in there. But I think the footnote itself, which I mentioned in my motion, and you go to footnote number 2, is most telling. It indicates the dissent urges that in considering Hall's vagueness challenge, which we understand to be the First Amendment challenge there, which would echo or mirror our First Amendment challenge here on freedom of speech, we are limited to the allegations of fact appearing in the indictment. What this means to me, and I'm suggesting to the court, is that all 7 justices were in agreement that you can take the allegations of fact in the indictment and make a determination of an as-applied constitutional challenge. The dissent's only issue was other facts were being considered. We don't want other facts being considered. We are more than willing and have indicated on the record that we will agree for purposes of a First Amendment challenge that the allegations, averments, facts in the indictment are to be taken as true for purposes of that challenge and that challenge alone. It's exactly what Hall suggests. It's exactly what 7 justices would have agreed on based on the footnote number 2. And therefore, we ask the court to find it right to be considered. If additional briefing then becomes necessary, once the court deems it appropriate to consider it as applied, both sides can present our position to the court, much of which has already been done so by co-defendants counsel, but then we can issue briefs and the court can determine law based on the allegations in the indictment as applied. Thank you.
And so, Mr. Sadow, on that point, I would say that one of the goals or purposes today is to complete our record on these issues. So I think that if your or any other co-defendant's intention is to make a as applied challenge firmly under the facts as averred in the indictment, this would be the time to do it. So, not right now, but through briefing.
I was going to say, that might open up a
in the
little longer
pretrial
argument.
stage. Yes.
How much time would you give us to do that, sir?
I wonder if we could stay on the same briefing timeline as we had with Mr. Schaefer's counsel.
I believe that was 10 days?
No, I think it was a little bit longer than that. We had the state replying in that instance.
We go to the 15th.
On the 15th. And then any rebuttal or surrebuttal, whatever we want to call it, by the 2nd.
Seems appropriate. Everyone agree?
All right.
Just to be clear, is that
I think they would be going first, since he's saying that they're doing a more specific as applied challenge based on the facts of this indictment, and then the state would have the ability by the 2nd to respond. I recognize that is a time when most folks are off, so if the state needs more time and wants to ask for it, we can take it up then.
okay? And Judge, just to be clear, would those supplemental briefs also include the issue of rightness? Any additional argument on the issue of rightness?
It can include whatever you want it to.
Okay, thank you.
Sure.
And if the court will permit, we'll try to do one consolidated brief, if that's agreeable to all counsel.
Sounds good.
Thank you.
All right. Let's transition over. I believe we should have, we had noticed for counsel for Mr. Meadows and Mr. Clark. I don't know if they were appearing they both in person? All right. Is there any way we could make some room at council? I know we're a bit tight here, but.
Don't need any room.
Okay, well then there you have it. We're going to start with Mr. Meadows? Sure. All right, sir, if you can introduce yourself for the record.
Yes, Jim Durham for Mr. Meadows. And Judge, for the record, I think I need 90 seconds.
Okay, and your client has waived his presence here today?
Yes, sir.
All right.
Simply, Your Honor, we're just asking for an extension of our deadlines. The 11th Circuit has taken, Mr. Meadows believes this case, as it relates to him, should be in federal court. I know we have deadlines of December the 4th as it relates to discovery. We have deadlines as it relates to pretrial motions on January the 8th, and we've asked simply for an extension as it relates to discovery February 1st, 2024.
I'm here. I don't know what happened. It's still live. Did they say they were taking a break or? Because they're still streaming. They just went off camera. Let's go back and listen because they cut off. Let's see what the judge says at the end because I wasn't listening. I was on my phone, so hold on.
briefs, and the court can determine law based on
one of the goals would
that might open up a
in the
little longer
pretrial
argument.
stage. Yes.
How much time would you give us to do that, sir?
I wonder if we could stay on the same briefing timeline as we had with Mr. Schaefer's counsel.
I believe that was 10 days.
No, I think it
Okay,
was a
yeah, I
little
think
longer
they
than
did
that.
wrap it up.
We had the state replying in that.
So 10 days.
The issue of rightness, any additional argument on the issue of rightness?
Agreeable to all counsel.
Sounds good.
Thank you.
All right, let's transition over. I believe we should have. We had
Someone's
noticed
here. Hold on.
For counsel for Mr. Meadows and Mr. Clark. I don't know if they were appearing in. They're both in person. All right. Is there any way we could make some room at council? I know we're a bit tight here, but.
Same mailman,
Okay,
same
well,
day, or same time every day.
We're going to start with Mr. Meadows? Sure. All right, sir, if you can introduce yourself for the record.
Yes, Jim Durham for Mr. Meadows.
Well, then it ended after that?
The pretrial motions on January the 8th, and we've asked simply for an extension as it relates to discovery February 1st, 2020.
They just cut it off. So were they done with him and they moved on to the next one, I guess? They said longer than 10 days. Jay, it's the 15th. What do you mean it's the 15th? Is there anything else we can watch? Or is that a son of a gun? Oh, yeah. We've got to talk about Rex Heuermann's wife, too, sometime soon. But anyways, I'm going to wrap this up, guys. If you didn't hear the Oxford school shooting live this morning, please check it out. Yeah, I didn't know what this was going to consist of. I thought it was going to be juicier than that. But hey, you never know unless you listen. But there's 35 of you still lingering. Thanks, guys. Briefs. Yeah, their briefs are due on the 15th. Thank you, Jerry. Thanks for being here. Keeping up on all the news abroad. All right, we'll see you guys soon. Let's roll our credits and dance it out. Oh, I know that lady's a creepazoid, and her DNA was on one of the victims. Bye, guys. Be sure to check out my other videos and playlists for more true crime content. And if that's not enough, you can join our Patreon. Don't have a tinfoil hat? It's okay. We'll make you one. It's that easy. See you guys in the next video.
See you later. Bye.
I don't give a damn. I don't really care about you and your problems. I don't give a damn. You talk way too much. I have heard enough about you and your problems. I don't give a damn. I don't give a damn. Damn, 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 damn. You wanna be, you wanna be, you wanna be with me. You wanna feel something real, but I'm feeling differently. You're making plans to get to friends, but don't wanna face the fact that I ain't got time, I ain't got time, I ain't got time for that. Staying up late, sleeping all day, dreaming about Cadillacs. Buying new shoes, hanging by the pool, sipping on Coke and Jack. Calling my phone when you feel alone, but I'll never call you back. 'Cause I ain't got time, I ain't got time.
Okay! You guys want one Jennifer or two Jennifer?
Hi, Jennifer. Thanks so much, Jennifer.
It's